Hello and welcome everyone to another InventRight.com YouTube show. Today we have patent attorney Damon Kelly on for our Basics series. And what we're going to be covering today is the basics of copyrights. Damon, what is a copyright? You're a patent attorney. I know you're not a copyright attorney, but I know you know this stuff, man. You can help us out.
It's all in the same basket of stuff. A copyright protects a work of authorship reduced to a tangible media, which is like a big mouthful of stuff saying when you put your artistic work down on something, anything, any kind of media, that's what copyright protects.
So some examples of that are written articles, books, someone giving a speech, artwork, music, software, photos. We're going to put a slide up here so you can see some pictures of some different things that you can protect with copyrights. So say that again, Damon, because that was kind of a mouthful. It sounded a little legal. Say that again.
It's a little legal.
Sometimes if you hear it twice, you're like, okay, I get it.
So it's a work of authorship, and those things that are up on the slide are examples of the statutory works of authorship that qualify for copyright. Things like architecture, literary works, a poem. A dance can be a copyright if it's in a tangible media, which can be sort of a dance sheet that says how to do the dance, or if it's videotaped or recorded in some manner or fashion. Music qualifies for copyright. And one of the interesting ones that you said, Andrew, was software. It's the reduction of the software to pages that is copyrightable, not the actual functionality of the software. And I think that's important for people to sort of keep in mind. The copyright doesn't protect the utility of it, but the artistic value of it.
Okay. Well, you know, one thing we deal a lot with patents when we're helping inventors and InventRight. One thing that's nice about it's a little gray sometimes. Is it really protecting this or is it really protecting that? Is it accurate to say that copyrights are kind of cut and dry? You have this and you have this, and is it very, very similar? Is it easier to protect a little bit?
It's easier, it's faster, it's automatic, all good things. But the thing to remember about copyrights is simply that you get rights just by having done it, and then you can get additional rights by registering. But the thing you got to really remember is that it protects your individual effort at doing it. So let's take an example of that so you understand what I mean. Let's say you're in Nevada and you create this amazing song, and it's just terrific, and you decide you want to copyright that. At the same time, in New York City, say, a musician creates the same song. You both can have copyright in that. That's unlike patents where only one person can own the invention. In copyright, it protects the authorship of that work. Whether or not that comes at the same time or at different times or before or after doesn't make any difference, as long as it's an independently created.
Okay. So we saw some pictures of things that are copyrightable. What are some examples of things that are not copyrightable that some people may think are? I think one is like everybody thinks they can copyright a name.
Yeah, no, names are not copyrightable, although if it was part of the title of a book or part of a book, that's sort of that's a little bit of a gray area, but typically names are not. The two that I get all the time are jewelry. Jewelry does not qualify, and clothing. Clothing does not qualify either. And I think you could make an argument for jewelry because there's a lot of artistic value that goes into jewelry, but it doesn't qualify. It's not part of the statutory works of authorship.
Oh, that's interesting. Yeah, I didn't know that one. I thought that jewelry is artwork, so it would be copyrightable. That's interesting.
Right, it just isn't. So it's just one of those weird exceptions.
Now, how about a sculpture?
Now, a sculpture for sure, and it doesn't matter what size it is. And in fact, you could take a picture of a sculpture. Oh, so here's an interesting thing. So you could have a sculpture, and you got a copyright in it. It doesn't matter how big it is or what color or whatever. If you took a picture of the sculpture, the picture could be copyright material independent of the sculpture. So copyright's really kind of a cool thing. It protects a lot of different expressions of art and a lot of different ways of recording the artwork in the media.
Okay, this is really good basic stuff. So for people that aren't familiar with copyrights, and this is our basics series. So that's what we want to get you familiar with, is the basics of these different intellectual property things. And one of the things you can do to protect your intellectual property is use copyrights. So how do you get a copyright, Dan?
Well, there's really, I mean, there's sort of three avenues. One is you could rely on just having the copyright that you automatically get when you create a work of art. So that's just common law copyright. So that's one way. Just so by creating the artwork, you get a copyright. The second way is
you don't have to mail anything in.
No.
You don't have to do anything. My understanding is, like, if you gave a speech in public, that's automatically copyrighted. Is that true?
Ooh, that's a good question, because
Is that stretching it a little? That's stretching it a little bit, but I think it's true.
The requirement is that it be reduced to tangible media. So if you've written down your speech and that's the speech you're giving, then it's copyrighted. If somebody records your speech, that's another copyright, available to them. Now, somebody else recording your speech of your, that you're reading of your written speech, that may be a violation of your copyright. But nevertheless, those are two separate copyright rights that you get for a public speech.
So what you're telling me, and a lot of people are surprised by this, you could file nothing with no government agency and you're protected by copyright laws.
Yeah, you are. And you need to give adequate notice, and you need to put a copyright, sign on there and a date and who owns it. But, other than that, you can sue for infringement of copyright on that alone.
Nice, nice. Okay, so what's the cost? I know it's changed a little bit. I had to look it up myself because it's changed, because I've been doing this stuff forever. It said a simple application, single author, same claimant, one work, not for hire, is $35, and a standard application, all other filings, is $55. Does that mean that if you do the $55, you can wrap a whole bunch of stuff in there? But if you're just doing one thing, you pay $35?
I don't know the answer to that question offhand.
I know, it's an odd question. I had to look up, because our students are always filing provisional patents. They're not doing that much stuff with copyright. It's automatic. I was just pulled that up on copyright.gov, which is where you could file a copyright. So can we talk quickly about that? The fact that it's automatic, you just put copyright in there. Why would you want to go to copyright.gov, the government agency, and actually file for a copyright? Why would you want to do that?
Well, so one of the things that comes with registration is the ability to sue for damages and get statutory damages. So you can get a statutory damage as opposed to actual damages. And let me explain what that means. Let's say that you're a musician and somebody copies your musical work. Let's say it's just one person copies it. If you go for actual damages, what are the actual damages for him stealing one copy of your music? Well, that might be, it might be $1 or $2. It may be a lot less than that, depending on what the normal licensing fee would be, or the normal fee for using that copyright. Now, if you go for statutory damages, that can be $10,000 per incident. So instead of collecting just $1 or $2, you could collect $10,000. You also make attorney's fees available to you. So it's a very good incentive for spending a little bit of money to have access to a greater amount of damages.
Okay, I got it. So it's additional documentation that could gain you greater damages if somebody violates your copyright.
Yeah.
Is that a good way of saying it?
Yeah, that's a great way of saying
Okay.
it. And that's registering
Cool.
with the Copyright Office on your own.
Nice.
And then
nice.
the third way that I mentioned is you can go to an attorney and have them do it for a lot of money. People come to me for copyright, and I typically tell them, just go to the copyright site and do it on your own, because it just isn't worth it for me to do it. It just costs too much money.
Yeah, and that's copyright.gov. So hopefully you guys felt like this is useful if you're interested in copyrights. This is just the basics. We didn't go into really complex issues or anything. It's either free or very affordable. A lot of the things you're doing, whether you're an inventor or you're not, automatically involve copyright. So make sure to put that little C with the date below it when you're doing things. It doesn't cost you anything. It takes you about 3 or 4 seconds to do it. So make sure to always do that.
Especially on your sell sheets.
Especially
on your sell sheets. Make sure you put a copyright notice on your sell sheets.
Yeah, if you've been watching our videos when we train inventors to sell their ideas, one thing is a sell sheet, which is an advertising piece. Always want to put a copyright on that. Damon's absolutely right. Thank you so much, Damon. Check out the other videos in our basic series as well, on provisional patents and on trademarks and on patents, and can get you up to speed on the basics, because a lot of people don't really have that foundation, Damon, and thank you so much for sharing.
It's a pleasure.
Appreciate it. All right. So I want to remind everybody to take care. keep inventing. Check out inventright.com. Learn more about how we coach and mentor inventors. Been doing it for 16 years with students in over 40 countries. And make sure to check out a whole bunch of other videos on our YouTube show. I get people all the time telling me, hey, I binge watched your show for 4 or 5 hours. So enjoy it. Take care, everybody.
Hi, this is Stephen Key, and I just want to thank you for watching InventRight TV. We're here to save you time, save you money, and show you how you can bring your products to market through licensing. So please, subscribe down below, click on the button, and tell your friends. Thank you.